All right, let's get you the latest on the Karnataka Hijab row. Now we're learning that the top court is all set to hear the appeals related to Karnataka's hijab face-off tomorrow, that is on Monday. Now appeals, remember, have been filed by a few Muslim students way back in the month of March in the second week against the Karnataka High Court. Now, High Court, remember, had dismissed their petition seeking permission to attend the classes wearing hijabs, ruling that wearing of hijab is not an essential religious practice. HC upheld the right to educational institutions to ban the wearing of the hijab inside its premises. All right, and on this note, I'm being joined by my colleague Harish live on the broadcast, who's reporting from the national capital. Harish, just for the benefit of our viewers, if you could also first of all break down what exactly was the Karnataka High Court's controversial order on this very contentious issue in the state of Karnataka, and also what can be expected in the India's highest court tomorrow.
Yes, good morning. That is right. Supreme Court will be hearing appeals filed by few Muslim girl students against Karnataka High Court judgment of March 15. High Court had, remember, dismissed the petition seeking permission to attend classes wearing hijab, ruling that wearing of hijab is not an essential religious practice of Islam. High Court had upheld right to educational institutions in Karnataka to ban wearing of any religious symbols, including hijab, inside its premises. The crucial hearing in Supreme Court tomorrow comes 5 months after the appeals had been filed, and despite repeated assurances, the matter had not been listed. So, High Court had said three important things while dismissing the petitions of Muslim students. One, hijab is not a part of essential religious practices of Islam. Number two, requirement of uniform is a reasonable restriction on the fundamental right to freedom of expression under Article 19, and that is very essential for maintaining decorum, uniformity, discipline, and equality. The High Court had also said that the government had the powers to issue the government order in this regard, and there is no case for its invalidation or quashing. Coming to the key arguments of the lawyers who had represented the Muslim students who were pro-hijab, the petitioners had argued that hijab is a symbol of modesty, faith, and belief, and constitutional right of freedom of religion, and hijab is an essential part of Islamic, intrinsic and integral to the religion. Therefore, not allowing hijab in schools and colleges is a violation of right to religion under Article 25. They also argued that dress and attire are part of speech, expression, and right to wear hijab is a matter of privacy of citizens, and that institutions cannot compel them to remove it. It's a sign of modesty. High Court had held that right of women to have a choice of dress based on religious injunction is a fundamental right. So these were the main arguments of the petitioners. At the same time, Karnataka government, which had defended the ban, had successfully argued to the High Court that, number one, right to religion is a fundamental right, but it is subject to reasonable restriction, and no right is absolute. So the biggest information coming in from the Supreme Court is that tomorrow this batch of petitions which have challenged the Karnataka High Court judgment will be coming up for hearing tomorrow.
All right, Harish, thank you so much for breaking down all those details for us.